Our next topic is offense of forgery or perjury, section 476 and section 476A CRPC. Uh, 476 CRPC procedure in cases mentioned in section 195. When uh, any offense is referred to in section 195, subsection 1, class B or class C, has been committed in or in relation to a proceeding in any civil, revenue, or criminal court, the court may take cognizance of the offence and try the same in accordance with the procedure prescribed for summary trials in Chapter 22 of the CrPC. When, in any case, tried under subsection 1, the court finds the offender guilty, it may, notwithstanding anything contained in subsection 2 of section 262, A, pass any sentence on the offender authorized by law for such offence, accept a sentence of death or imprisonment for life or imprisonment exceeding 5 years, if such court be a high court, a court of session, a district court, or any court exercising the power of a court of session or a district. B. Sentence the offender to simple imprisonment for a term which may extend to 3 months or to pay a fine not exceeding 1,000 rupees or both, if such court be a court of magistrate of the first class, a civil court other than a high court, a district court, or a court exercising the power of a district court or revenue court, not inferior to the court of collector. C. Sentence the offender to simple imprisonment for a term not exceeding 1 month or to pay a fine not exceeding 50 rupees or both, if such court be a criminal court or revenue court other than a court referred to in class A and class B. Third, the power conferred on civil, revenue, and criminal courts under this section may be exercised in respect of any offence referred to in subsection 1 and alleged to have been committed in relation to any proceeding in such court by the court to which such former court is subordinate within the meaning of subsection 3 of section 195. For any person sentenced by any court under this section may, notwithstanding anything hereinafter contained, appeal A. In the case of a sentence by High Court to the Supreme Court, in case of a sentence by a court of session or district court or a court exercising the powers of a court of session or a district court to the High Court, C. In any other case to the session court. 5. The provisions of Chapter 31 shall, so far as they are applicable, हेलो अस्सलाम हाँ जी की हाल है हाँ हाँ चलो ठीक है ठीक हो गया The provisions of Chapter 31 shall, so far as they are applicable, apply to appeal under this section, and the appellate court may alter the finding or reduce or enhance the sentence appealed against. 476A CrPC, forwarding of cases for trial by courts having jurisdiction. Subsection 1. If the court in any case considers that the person accused of any of the offences referred to in section 476 CrPC, subsection 1, and committed in or in relation to any proceedings before it, should not be tried under that section. Such court may, after recording the facts constituting the offence and the statement of the accused person as herein before provided, forward the case to a court having jurisdiction to try the case, and may require security to be given for the appearance of such accused person before such court, or if sufficiently security is not given, shall forward such person in custody to such court. The court to which a case is forwarded under this section shall proceed to hear the complaint against the accused person in the manner herein before provided. Action under section 476 CrPC is not to be launched as matter of course and for every offence alleged to have been committed in the course of judicial proceedings. Such an action must necessarily be taken in public interest and not as a revenge by the party to satisfy their private grudge against the other party. It is only after a finding that it is expedient in the interest of justice that an inquiry should be made into an offence referred to in section 195 subsection 1 clause B and C has been recorded, and a complaint made by the presiding officer of the court and forwarded to a magistrate, that security for appearance of the accused before that magistrate can be ordered, or the person accused should be taken in custody. When a court before whom an offence mentioned in section 195 CrPC is committed wants to take action against the delinquent, it can only proceed under section 476 CrPC. A finding that the lodging of a complaint is expedient in the interest of justice is essential. Omission would vitiate the order. Section 195 and 476 are intended to be complementary to each other and must be read together. Provision of section 476 CrPC is legislative interpretation of section 195(1)(c) CrPC, both in the case of clause B and clause C of section 195 subsection 1 CrPC. The offences must have been committed in or in relation to the proceedings in the court. As a matter of fact, section 195 CrPC bars prosecution, prevents prosecution for contempt of lawful authority of public servants, for certain offences against public justice, and for certain offences relating to documents given in evidence, except on complaint of the authority of the court concerned. Section 195 CrPC lays down a rule to be followed by the court, which is to take cognizance of offence specified herein, while section 476 contains directions for the guidance of the courts, which desires to initiate a prosecution in respect of an offence alleged to have been committed in or in relation to proceedings in the court. Section 476 requires that court desiring to put the law in motion to prefer a complaint either suo motu or on an application made to it in that regard, to justify the court in initiating prosecution, it is necessary to hold that it is expedient in the interest of justice that an inquiry should be made into an offence referred to in section 195. Accused, the public servant can't be convicted without complaint. Police not submitting any report under section 173 CRPC before the magistrate, and said magistrate passing order for cancellation of case merely under direction of the trial court. Procedure adopted by trial court illegal and irregular. Order passed by trial court directing magistrate to try complaint under 476 CRPC for offence defined in section 211 PPC, and subsequent order passed by magistrate whereby he has cancelled the case and discharged the accused not sustainable. Section 476A deals with the forwarding of case for trial by force and a jurisdiction to take cognizance under section 476 CRPC on the finding that the case should not be tried under that section for reasons relatable to the facts and circumstances. In that situation, after recording the facts constituting the offence and the statement of the accused person, the case can be forwarded to another court having jurisdiction to try the same. Wording of section 476 ACRPC make it clear that the court ordering a prosecution has to come to a definite finding that it is expedient in the interest of justice, that an inquiry should be made in respect of the offence alleged to have been committed. Undoubtedly, uh, the court should order a prosecution only in the interest of justice and not to satisfy the private grudge of a litigant. In these proceedings, the court has to decide the question of guilt or innocence of the party against whom proceedings are taken. But before setting criminal law in motion, the court should exercise great care, and it must be satisfied that there is reasonable foundation for the charge in respect of which the prosecution is ordered, and that it was in the interest of justice to order such a prosecution. Action under section 476 CRPC is not to be launched as matter of course and for every offence alleged to have been committed by judicial proceedings. The provisions of section 476 and 476A of the code are other similar and relevant provisions have been put in statute books not merely for decorative purpose but with a definite object to ensure that the stream of justice does not become pregnant with impurities. Where no reason shown which could be considered sufficient to spare the accused person of their liabilities to be prosecuted for having given false and incorrect statements before the court of law, order of trial court declining to prosecute them set aside. Any application filed under section 476 or an appeal thereof is to be governed by the provisions of civil procedure code and not by the provisions of code of criminal procedure. Court has discretion to take cognizance of the matter as was evident from provisions of section 476 CRPC. High Court is itself competent to take proceedings against the accused under section 193 PPC. Accused would not be liable for action under section 476 read with section 197 and section 34 PPC. The High Court, while granting him protective bail, does not take into consideration documents alleged to be forged which were annexed with bail application. Observations, if any, made by a High Court while dismissing, for example, contempt application will not influence the lower court. High Court acting its divisional jurisdiction or constitutional jurisdiction is the court within the meaning of this section. High Court may order institution of complaint without preliminary inquiry. In each individual case, the court has to decide whether in the interest of justice a preliminary investigation is necessary in a case where an offence has been committed outside the court and not in the presence of the judge. It would certainly be judicious, if not incumbent upon the court, to hold a preliminary inquiry in order to find out for itself whether such an offence was really committed. But where an offence is committed in the presence of a court or from a perusal of the record, it is of opinion that it is necessary in the interest of justice that a further inquiry into the matter should be made in the criminal court. It may make a complaint to that effect to the nearest magistrate without making any preliminary inquiry. There must be material on the record to show that the court has applied its mind. Where this has not been done, the foundation of the action is lost. The complaint, therefore, must be held to be incompetent. It is necessary for the court to consider whether it is expedient in the interest of justice to launch proceedings under Section 476 CrPC. The court should not allow itself to be converted into a machinery for achieving the private ends of parties. Bar under Section 195 CrPC. Bar under Section 195 would not apply to a case where a forged sale agreement has been made in base for suit for specific performance to deprive owners of their valuable right of ownership. Alleged forged documents which were under challenge in the civil court had come into existence before the filing of the suit. Case against accused, therefore, could be registered independently of the move by the civil court and investigated. But where every registration of case is nulla fide and unwarranted, it should not be allowed to be perpetuated. Accused or tenant resisting execution of ejectment order manufacturing forged agreement allegedly executed by owner of premises in their favor, complaint should be filed direct before the competent court without invoking provision of section 195 GRS. Offence under section 193 PPC alleged to have been committed before a bench of high court. Complaint under section 476 may be disposed of by the same bench. No special bench need be constituted. The need for dealing with such like case very firmly and severely is so obvious that no further observation is necessary in this regard. What was held in uh, Kareem Khatun case, court of law must have strong and compelling reason for not proceeding against witness and persons who perjure themselves before. Perjury is one of the most heinous social and moral offences. It is not only an offence punishable under the law, but is also against injunctions of Holy Quran. It is an evil which tends to disturb the very basis of social order and make a mockery of the judicial system, whether it is Islamic or otherwise. Any person who deliberately tells a lie during the solemn proceedings of a court of law know fully well that he is thereby likely to ruin the life or reputation of an innocent person or put into jeopardy his liberty by falsely involving him in a criminal case or cause damage to his property does not deserve any lenience, any concession. Persons who deliberately tell a lie in courts of law and are proved to have committed this offence should be awarded deterrent punishment so as to serve as a warning to others in order to minimize the litigation in the courts. For the cognizance of offence of perjury, its trial is governed by Chapter 20 of the Code. Failure to follow procedure prescribed would render conviction illegal. In respect of marginal cases, courts are supposed to take caution from the case wherein the motivation is provided by an urge on the part of the accused himself. The court has to consider before ordering prosecution whether there is any reasonable probability of prosecution ending in conviction. Nature of jurisdiction. A jurisdiction under 476 CRPC is discretionary. Court may refuse to initiate proceedings under this section even where the allegation of falsity is provable from record. Respondent, that is husband, making statement in the court that the parties have compromised and that he would deliver the custody of the child to the petitioner. He also admitted that he had not contracted any second marriage. However, it revealed later on that he had contracted a second marriage, but not Rushdie had taken place. High Court declined to launch proceedings under Section 476 CRPC, declaring that it is not in public interest rather to be used as a handle in the hand of one party to damage a private vengeance or satisfy a private grudge against the other party. Witnesses are not to be prosecuted because they give evidence which is contradicted at two different stages of the case. It is only where a court is expressly of the opinion that it is in the interest of justice that the witness should be prosecuted, that a prosecution may be lodged. A complaint as orderly not be made, and much less at the instance of a private party. Where there is a long delay in filing complaint for perjury, matter no more pending in any court, complaint not entertained, application under section 476 much delayed, matter not agitated at the time of making of false statement, courts below not exercising discretion for not taking cognizance of offences under section 193 and 195 PPC. Order held unexceptional. Order held unexceptionable, a judgment debtor filing in Supreme Court documents in support of his allegations of perjury against degree holder in appeal, but such documents neither brought to notice of Supreme Court nor passed into service. Documents filed allegedly supporting allegations of judgment debtor but not duly proved. Entries of name of degree holder's father as given in Nikah carrying no evidence. It is for the presiding officers to uphold the prestige of the courts and not the litigants to achieve gratification of their personal revenge and vindication of court's honor. Section 195, subsection 1, class C, bars the cognizance of the offence of forgery and certain offences when the offence is committed by a party to any proceeding in court but creates no bar if such offence is committed by any person who is not a party to any proceeding in court. Where the offence is not committed by parties to any proceedings in court but long after the proceedings in court, the case would not fall under 195 subsection 1 class C CRPC. Criminal prosecution can be launched in respect of a document which is the result of fraud and forgery and which is subject matter of a civil suit, provided the said forgery is alleged to have been committed prior to the institution of civil suit. Bar uh, only relates to those cases which have close nexus between the offences and the proceedings of the civil case. Court should not launch a prosecution unless it considers that it is expedient in the interest of justice. The discretion should be exercised with great care and caution and should not be used as a tool. Action under section 476 CRPC is not to be launched as matter of course but for the public interest. Such an action must necessarily be taken in public interest and not to be allowed to be used as a handle in the hand of one party to wreak a private vengeance or satisfy a private grudge against the other party. No prosecution ought to be directed unless there is a reasonable probability of conviction. A prosecution for an offence under section 193 PPC should not be ordered for mere ventilation of private grievance of parties. Prosecution should be launched only when there is a reasonable certainty of conviction, strong footing There should be ordered where it is considered expedient and essential to punish the delinquent, and not merely because there is some inaccuracy in the statement which may be innocent or immaterial. The prosecution should be sanctioned only when perjury is deliberate and conscious and the conviction is reasonably probable. If the false evidence is clearly immaterial to the evidence of the case, a complaint should not be made. A witness is entitled to a locus penitentia or an opportunity to correct himself, and before directing his prosecution for perjury, the court should see whether he has availed himself of the same. Where a plaintiff alleges commission of perjury in respect of documents pertaining to suit land, case falls under section 195 CrPC and court should proceed under section 476 CrPC. Whereunder, if the court after inquiry or otherwise comes to conclusion that it was expedient in the interest of justice to proceed in the matter, a complaint has to be made under provisions of section 476 CrPC, and the question as to whether it was expedient to file complaint is to be resolved by the trial court and not by any other.